right. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, March 12th, 2025. We are operating off of voting list number 12. And we're going to start off with Senate Bill 466.
So Senate Bill 466, this bill was before the committee last week. The bill prohibits, as drafted, the bill prohibits a caregiver, family member, or household member from knowingly and willfully taking property from a vulnerable adult or an individual aged 68 or older with the intent to deprive the individual of that property. Violators are subject to graduated penalties based on the value of the stolen property. There is an amendment in your voting packet. This is consistent with the language that was passed out of the House on the House cross file. And the committee was actually discussing this language during the last voting session. If I can find, thank you. The amendment would strike provisions of the bill and instead, if I could direct your attention to page 9 of the reprint. At the bottom of page 9 would provide that a person who is a caregiver or family member or household member of an individual may not knowingly and willfully obtain the property of the individual with the intent to deprive the individual of the individual's property if, and on to the next page, 1, the individual is a vulnerable adult or an individual who is at least 68 years old, and the person, being the perpetrator, knows or reasonably should know that the individual is a vulnerable adult or is at least 68 years old.
We have representatives from the Attorney General's office here. If you could just speak to the amendments and what the dialogue was like in the House, and you can come on up to the podium if you like. Welcome.
Good afternoon. I'm Lisa Martz. I'm Deputy Director of the Medicaid Fraud and Vulnerable Victims Unit in the AG's office. I actually thought the amendment had to do with in the House with the consecutive versus the concurrent. Okay, that's what I was. So what is the question with regards to the other change?
So the question was regarding. I think it was focused more on the prohibition itself and whether sort of the situations that would be covered where a person obtains property with the intent to deprive, and I think the focus was on obtaining and deprive.
So I think what the questions were before were there were questions about the intent to deprive, and there were hypotheticals involving, your aunt giving you your antique gun or something like that. So what we would propose is perhaps amend it even further and mirror the theft statute. And in that provision where it says a person who is a caregiver to a family member or host, whatever, may not knowingly and willfully exert unauthorized control, because that's the wording in the theft statute, and obtain the property of the individual, which would counteract that whole intent, because it would be unauthorized control, which would mirror what's in the theft statute. Is that in there already? It is not. We would ask that that be amended to be able to address that intent to deprive issue.
That was the.
Because I think that was the hang up. Yes. So I believe it's in the provision he was just talking about, and I don't know exactly what line, because mine's the House bill.
I apologize. Thank you for letting me ask this question. Could you just repeat to me, I do like your suggested language, but where, especially if you're following it.
Senator, yeah, he's going to pull it up for you. It's on page 9. He's going to tell you right now.
Thank you.
Right. So it's the bottom of page 9 of the committee's reprint. And I believe it would, correct me if I'm wrong, it would now say a person who is a caregiver to or a family member or household member of an individual may not knowingly and willfully exert unauthorized control over and obtain the property of the individual with the intent to deprive the individual of the individual's property.
And my modest question, Jamie, where in, I know we're borrowing this already understood language, which I think is great. Where is it coming from again? I just didn't hear that part.
So obtaining and specifically intent to deprive.
Oh, no, Jamie, let me, I know where obtain came, I looked up all this
Right,
definition, you know, a little research.
I believe,
just this new language about the.
I believe that's you indicated the criminal theft statute?
It's in the criminal theft
Criminal theft.
statute, Senator James,
Thank you.
already, so that we figured it would mirror it, because I looked for case law, there is no real case law, but the case law discusses unauthorized control when it's discussing theft cases, so I figured that would probably be a solution.
Thank you, thank you. I like it.
Before we, so Senator Folden, and then I'd like to just adopt this amendment so we could work off of it, but go ahead, Senator Folden.
We can go ahead and adopt the amendment, Mr. Chair. I don't want to hold that up.
Move to
That
adopt.
solves half of it.
Okay,
Move
great.
to adopt.
Second.
All right, is everyone okay adopting the amendment? All right, those three as amendment, Senator Folden.
So this amendment addresses, thank you, Mr. Chair, this amendment addresses our concern about the intent, which is an element of the law.
Yep.
The last question that I would have then is the 68-year-old, we're setting a number as 68 without any other
So,
required elements of vulnerability, not being able to be self-sufficient, anything at all. We're just grabbing 68 and we're saying if you're 68 with no other critical factors, then you could be charged with this as well.
so I would say that's the way the law has been. I mean, that was the original, the only thing we've added is the caregiver part. The 68 has been there for
Yeah,
years.
no, I love it because it helps with when people want to be judges and stuff like that. It's time to move off the bench because
Look,
apparently after
look,
68.
I'm 58, so I'm pretty
Apparently after 68,
close.
you are not able to think on your own. So I appreciate that because this is a wonderful tool in the future.
No, that was, I believe, the original intent back when that it was passed was based on most people retire around that age, and that's when they come into money, and that's when people will be vulnerable. I would argue that I, as a prosecutor, have to prove that they were, coerced or undue influence or whatever. The reason we really wanted this bill for the caregiver provision was that we saw so many people in nursing homes that maybe have dementia.
Yeah.
They're not aware that, they've got their debit card in the, or checkbook in the
No, I think it's great,
nightstand.
and I'm glad that we were able to solidify it with the intent because that was clearly missing, and I was shocked that was missing from the Attorney General's own bill, so, but thank you.
You're welcome.
Next year, I'm making my
Thank you.
judges bill for 95 years. I'm gonna get all y'all back.
I'm not going to comment on that.
Oh, can I just
All right,
clarify though?
so just for council to tee us up for the amendment to the amendment, so for the theft statute, can you just please repeat and tell us where you'd like to, where you will insert the definition?
Not a definition, just the additional language. So that will be after the word willfully. And I want to be clear that I have it down as an and, not an or. So let me read the whole thing. A person who is a caregiver to or a family member or household member of an individual may not knowingly and willfully exert unauthorized control and obtain the property of the individual with the intent to deprive the individual of the individual's property if, and then the language about vulnerable adult or, I believe you're right.
Control over.
Yes. So they may not knowingly and willfully exert unauthorized control over and obtain the property of the individual.
All right, pending motion open. Senator James, you have your,
Yes, thank you. I just want clarification because my colleague to my right, literally and figuratively, I guess, has brought this up a couple of times, so I do want to just make sure I understand. The 68 was chosen a while ago. I don't know how many years ago. I don't know if it's so long ago that 68 was not only the age of retirement, but was also an age where we began to think people were more failing than they are today. But just so I understand, that 68 has been in statute already in a couple of other areas. This is this gap that the Attorney General has located for this group of people, but it's usually that they're vulnerable. But I just want to understand, this is now a new additional penalty. I know it could be consecutive or sequential.
Concurrent.
Concurrent, thank you. I know that, but is it possible that you get ensnared under this statute when the individual is 68 years old, full stop, they're not vulnerable in the least? Because the way I read it, it says you are either vulnerable or you're 68, and then there's and the person knew you were vulnerable or they knew you were 68. So it's you're 68 and I knew you were 68 and I get additional penalties for your age alone. I could be reading this wrong. Or somehow does vulnerability come into this at all? Is there any vulnerability in that setting that you are 68, I knew you were 68, and with that alone, no vulnerability, you can get additional penalties? Is that correct?
That is correct. I mean, the 68 is the cutoff.
So
I mean, I don't envision using it that way, but yes, I suppose
I
a
appreciate-
rogue prosecutor could.
So then I'd like to know what's the policy behind that? I absolutely get the vulnerable part, and I'm for it. So I'm just trying to figure out 68, 68, nothing else. How do you go back to your community and say, we have extra penalties because I'm 68, well, I'm not, you're 68, and I knew you were 68, and I get to have 3 years, 5 years, 10 years because what is the state's policy?
Well, all I can speak is to the general history of the statute, because 68 was put in there years before, and from what I could glean from the notes, was that it was because of the retirement age. And I couldn't tell you how many years, I don't know.
Sorry, so just to clarify, because this is modeled, we're filling a gap, modeled after some earlier aspects to this. So in earlier iterations of this, or ones that exist now and will continue to exist in the future, that have a 68, it's also, the other two penalties or areas where you can get trapped with this is also, you're 68, I know you're 68, and I can nail you with more penalties. Is that true with those other one or two existing?
What exists right now? What exists right now, yes, if you're over 68, but you have to show undue influence, coercion to get that. So the change that we're looking at is removing that undue, because the case law came down saying you have to show that, and then we were, all these people in these nursing homes, we didn't really have, because they were caretakers, they had access.
I
And
don't
they
want to
didn't.
get off, I'm so appreciative.
Yeah, so I'm saying
Advocacy.
the law already exists like that. They're
Right.
already 68. So you could, I guess hypothetically, prosecute based on 68 right now. Yes.
Without there being a vulnerability, without there being
Yes,
anything
yes,
else.
as long as you show undue influence and coercion, yes.
Okay, thank you.
So along the same lines, are there other statutes beyond this one we have in our hands which use 68? So if we, for example, were to change the age here to 70, which is the same age as the constitutional senility of judges in Maryland, if we were to change it to 70, would it cause an inconsistency between this statute and other related statutes?
Not that
would
I
be-
know, not that I know of, Senator. I think this was just this statute, and they just picked 68. So if you wanted to raise it to 70, or, well, not many people lived in 95. I think 68 was picked because of the retirement originally.
Do I sense there's a
Let's just
An
adopt,
interest in
let's adopt
raising-
the Second Amendment first, and then we can continue. Is everyone okay adopting the
yes?
theft language?
Yeah.
Okay. All right, that's adopted.
So in Maryland, we already have a situation in the state constitution where judges, when they turn 70, are over the hill.
Just before you do that, let me council's going to do a code search real quick. Just
Sure, yeah.
That doesn't affect what I want to change.
I'm with you. It doesn't affect that part of it. The bill would still get at what we're trying to do, which is those depriving vulnerable.
The people that are, I'm prosecuting, yes.
I just, you understand, I don't like giving an arbitrary number with no other factors. Yeah, I mean, we could leave it 68 and vulnerable,
And do it with the rest of the stuff.
or just,
I would argue from a prosecutor standpoint that that would defeat the purpose of saying stealing from grandma that maybe doesn't have undue influence,
Well, then we get her here.
yeah.
get rid of the number altogether.
The undue influence is what we're doing this.
Yeah.
This statute would fill that gap for you. That's what we're doing. We will consistently.
Yeah.
Make it vulnerable and 68, to raise the age, one or the other.
Or if you remove the age component to it, does it change the substantive part of the bill, which is about protecting
So
vulnerable?
I would argue that you could have someone in a nursing home potentially who is still, well, I guess they wouldn't be in a nursing home then if they
Right.
weren't vulnerable, so.
Unless they had they could be there in rehab.
No, there are, that's exactly.
I will say, we did have a case where a woman was in a coma. She was in rehab and she was in a coma, and she was under the age. She was in her 50s, and there was a woman who falsified her healthcare license and got a job, and because of that, and she had access to that patient while she was in a coma and got to her checkbook and did a couple trips down to Virginia and casinos and that kind of thing.
Is that not a vulnerable?
No, when we argued, she was a vulnerable,
I was
yes.
gonna say that if you're incapacitated, you're clearly
Right.
vulnerable. You're not.
But you could have someone.
Care for yourself. I mean,
Yeah.
vulnerable is the idea that you're unable
agree.
to maintain and care for yourself.
Right.
So I just was,
I mean, look, just anecdotally, one of the, facilities, I go visit him all the time, and last time I was there was unfortunately someone that was, in her 30s in one of these rehab facilities that,
I suppose if they're younger and they have Alzheimer's, we
Yeah.
would argue that they're vulnerable.
so
They
then,
qual-
to the senator's point, I mean, I'm just asking, I mean,
I'm sorry, what?
does the age really,
Does the age really matter?
what you're trying to do.
For what we're trying to do, no.
Correct.
But I don't know, I can't think off the top of my head if it would affect other prosecutors that want to do, because this is their original bill. Everyone I'm prosecuting is everyone, all my victims are vulnerable.
Correct, and that's what we're trying to affect.
You wanna ask them to come back to us?
If you have intent,
You want to ask?
Yeah, ask them to come back to us.
Yeah, because I'll.
Tell us that substantively that changes.
if you have intent and you have vulnerable, that meets the two prongs that this bill.
Yeah, I can maybe make a call and see.
Just make a, and ask them if it's okay to do it consistently.
Okay.
The other statute, I don't know if there's one or two, but one, undue influence, this one. So third one, we do the one.
There's nothing that around a number like that. I don't know, other than the one thing where he was talking about before, that maybe it originally was why it was even put into this language.
'Cause they
But this is
violate?
specifically about a vulnerable person who is being victimized with an intent to deprive them of their property or possessions or monetary. That's the element of this. That's the two main components of this. So the bill meets that standard. Why wouldn't we have a solid bill?
Also, if there are no cases ever prosecuted just on 68 alone, then you know it's superfluous and you don't need it.
Just tell them that,
Yeah, check and see. Just because you're 68.
Can we?
Like, that's going to be a problem.
Is it, let me ask you this, Mr. Chair, would it be inappropriate at this time that we would remove the arbitrary number of 68, move forward with the intent, which we've added, move forward with the vulnerable adult, and then, I don't want to delay the bill, that it moves forward, and then if there's an amendment that she finds out differently, like, can we ratify just excluding the age right now altogether? Because as I'm hearing from the AG, the intent of the bill is being met now by the vulnerable status with an intent to deprive. As simple as that. So the number is irrelevant.
It does seem to help us.
And I think that that's actually, even below that, like the AG said, the vulnerable component is important. if you,
Yeah, if you're in a coma,
early onset
you're
Alzheimer's or you're in a
58.
coma.
You get you. Not everything they did in the past was right. I don't think the age should be in there
Yeah,
anyway.
that's good.
Age alone, it's like saying race. It means nothing.
Right.
It means nothing.
If I find something different, I'll come
Yeah,
back.
if there's something different, but
We'll move it.
would there be any heartburn with that?
Yeah. All our cases, like I said, are vulnerable, so it would not affect
I
our
think that way I like the bill. with the
So,
number.
look, I almost think that taking the number out would be better for your policy goals, of being able to go and.
Yeah, I don't have a problem from our unit.
I just don't understand what other cascading impact we'd have on the rest of the statute by removing it. And that's my only hesitancy, but I think you could just not make it apply to this this new piece of law that we're creating, yeah.
So can I make a motion?
Hold on, yeah, Senator Muse.
Yeah, I would just say, if you find out that there's a problem, we can fix it on the floor, so we don't have to hold it up today.
Okay.
Let's just strike that, and if there's a problem, we'll amend it on the floor. Is that okay, Mr. Chair?
Oh, so I've been told, senators, that the reason 68 was picked was because the SAFE Act, the Financial Exploitation Act from CPD, from Consumer Protection, that's where the 68 came from, because it mirrors that.
But that has nothing to do with.
I'm just saying that's where that comes, the SAFE Act is the financial exploitation, where the banks have to report when funds start getting, that's where it comes from.
And
That's
that
where
doesn't
68
change
comes
that
from.
for
But
this
that was
purposes of this.
Taking it out of this does not change it.
Change that at all.
And do they have any other factors in the state act? or
So
just
council also
68?
informs me that under the state statute, which mirrors the federal, it's actually 65, not 68.
Yeah,
So
so-
that means it don't matter.
So,
So it doesn't,
65 is the federal?
state,
Oh, the state, okay.
so can I make a motion that we,
So we're all over the place.
are you open to a motion or do you?
do all, if you have no number, but I, again, just don't know what other, ancillary,
I personally don't see a problem with it. I'm just getting what I'm getting from my
I like it a
office.
lot better with that. I think it. So I'd like to I make a motion then that we remove the age requirement.
Second.
That was that, and that, simple as that.
Second.
Yes.
Yes.
And then I would make a motion to then move the bill with that amendment.
Second,
Correct, with the idea of understand, right.
absolutely.
If I'm correct, then that one provision would say the individual is a vulnerable adult and just take out the
Period.
or.
Yes,
Vulnerable. And two, the person knows a reason to know that.
I do too.
Is a vulnerable adult.
You keep both of those vulnerable.
Just take out the ors.
Yeah, just the, or,
Correct.
yeah, you're developmentally disabled, or.
So can we move the bill then?
all right, so we've adopted that amendment, so there are, I think, a total of 3 amendments on this. Bill. So there's been a motion for favorable on the bill, it's been
Second.
seconded.
Motion, so moved, whatever.
All right, is everyone okay being recorded in the affirmative? And that's how the law is made, I don't know. There you go.
Thank you very much.
Thank you for being here.
I don't know if that's invigorating or terrifying. Yes, yeah, the answer is yes. Okay, yeah. Reassuring or terrifying, I don't know. All right.
What?
Senator West.
Language here. And the first was the individual is a vulnerable adult or an individual who's at least 68 years old. And then there's the second, it says, and the person knows or reasonably should know that the individual is a vulnerable adult. Are we going to leave that language in? Yes. Okay, so the person is a vulnerable adult and the person who is charged knows that the person isn't. Okay, fine, I agree.
So I'll read it for the committee here. So the new prohibition will read, a person who is a caregiver to or a family member or household member of an individual may not knowingly and willfully exert unauthorized control over and obtain the property of the individual with the intent to deprive the individual of the individual's property if the individual is a vulnerable adult, and the person, that being the perpetrator, knows or reasonably should know that the individual is a vulnerable adult.
All right, so we're gonna motion to reconsider the vote by which the bill passed. Is that okay? Right now, the bill's, who wants to jump on as a sponsor? Senator Folden, Senator West. I'll jump in. Senator James.
As long as it doesn't warn you.
Senator Charles. Senator Love. Senator Muse.
All right, I have Folden, West, Smith, James, Charles, Love, and Muse.
Senator
Waldstreicher.
Senator Sidnor. Yeah, I'm trying to.
Anybody else?
I sit next to you, I feel vulnerable every day, I'm sorry.
No comment. All right. All right. All right, now the bill is before you as amended. Motions for a favorable. It's been seconded. Is everyone okay with being recording the affirmative? All right. Senate Bill 466 passes unanimously with amendments. That's a good bill, man. It's a good bill. All right, so we're now going to go on to Senate Bill 432.
Pull this up here. 432. Senate Bill 432 is an administration bill. As drafted, it alters various statutory provisions relating to waiting periods for the filing of a petition to expunge a conviction under 10105 and 10110 of the Criminal Procedure Article. It also expands the list of misdemeanor convictions eligible for expungement under 10110, and expands the factors that a court must consider for an expungement under 10110. It prohibits the Maryland Judiciary Case Search from referring in any way to a charge resulting in a null pros, which required drug and alcohol treatment marked STET on the docket at least 3 years previously, and charges of possession of cannabis in a case with electronic records if the charge resulted in a conviction that was later pardoned by the governor. There is one amendment in your voting packet. And that is I'm not seeing it.
You can have it.
The amendment would make a couple of changes. First, and I'm looking at Amendment 713223. The amendment makes changes to 10105, which generally applies to things like PBJs, stats, null process. It also includes a couple of convictions. It involves things like NCRs for some minor offenses. But it would provide that in determining whether the person is entitled to expungement, the court shall consider, to the extent applicable, the person's success at probation, parole, or mandatory supervision, and that the person has paid any monetary restitution ordered by the court in the original proceeding or does not have the ability to pay the restitution. There is a corresponding change that's made to 10110, which is on page 6 of the reprint. And then it strikes a few of the prohibitions that were included in the, or would be newly eligible for expungement. And let me just pull that up for you.
Miles, you probably know this by heart. Do you know which ones, what the sections are? What the code sections?
Come on down.
You know, it's a lot of numbers. I wouldn't say I know them by heart, but I do have them written down. Just to start, the charges that we are removing from the bill, that would include 8-610, counterfeit prescription, 9-408, resisting arrest, 9-501, false statement to an officer, and 9-502, false statement while under arrest. The charges that we're keeping include 8-204, which is credit card theft, 16-101, which is driving without a license, and finally, the one that we are keeping is 8-106, issuing a bad check.
And why this bill is before us? Is everyone familiar? All right, so I'll speak through council, but Jamie, you want to go ahead and just tell, are you, well, if.
Oh, you mean that Abbott? Yeah, he was found to have not completed his parole by some rule fraction that was not violent. And then
So I don't know the particular, I don't know how long Abhishek was on his probation, had a violation of probation. How long ago was that?
To my understanding, he was on probation for, he went for an expungement maybe 20 years after his
20 years
conviction.
later, and he had
It was
a
a long
technical
time.
violation
And he found out he couldn't get an expungement.
in the first, few years of his, or for a few months. I don't know how long it had happened, but it was early on. 2 decades later, he goes for an expungement, an eligible expungement, and he couldn't get it because he had violated on a technical violation. And so the court ruled that he was ineligible. So this bill seeks to rectify.
Is this Coleman?
Yeah, I was about to say also Harold Coleman, who was here that
Yeah.
day as well. He is another person
Yeah,
who violated back in the 90s. He initially picked up his first charge, I think, in the 80s.
Different, but his wasn't.
Different, yes, but
This, not under this, yeah.
He's advocating for us.
So that's what's important to understand, what we're pulling out, what we're putting back in.
and I'll also point out there was another young man who came and talked about his own violation as well during the hearing as well, and he's here advocating on behalf of others too, not just himself.
Thank you, Mr. Chair. I just want to confirm, I want to bring up Coleman one more time, but did you say that the 9 series, the ones dealing with like resisting arrest and all that, were no longer going to be? So
They're not in the bill anymore.
They're not in the bill anymore?
So I'll point them out again.
9408,
If you look
9501.
at, and I'm looking at the reprint, so this page numbers, yeah, so page 47, lines 10.
Yeah,
All of those have been stricken from the bill.
okay, good. Okay,
Yes, and just to repeat those again, those 3 that you're specifically talking about.
Yeah.
9-408 is resisting arrest, again, you'll see that stricken from the bill. 9-501 also is stricken, and 9-502.
Okay.
Those are the 2 false
And then-
statements.
and then the 8, I'm sorry.
501 is false statement to an officer, 502 is false statement while under arrest.
Okay. And then 8-610, did that one stand?
That one's gone.
And what was that one?
That's counterfeit prescription.
Okay. So the other 3 then, I think,
Yes.
stay.
Correct.
Right. So, Mr. Chairman, here's my question about this, and I understand about the technical infraction. Is there, and we've had this bill come up time and time again, and there's people that are like Coleman, who I've had several discussions with, who had been released, he made he messed up on his, wasn't a technical infraction, but it wasn't an egregious issue either. Gets rearrested or has another contact with police, and now he's never eligible to have that removed, anything. So if you're talking about some type of restorative justice, then I understand the part about the technical infractions, right? Causing problems for the one person. But, I've had numerous conversations with Coleman, and Coleman's, working in a job, and he's working in a job for the state and is ineligible for any type of promotions because of this laying on his bill, or I'm sorry, on his record, even though it's been 20 years since. So my question is, why are we stopping at something like that when, if it's been that far gone removed, is there any thought process to entertaining an idea? And I'm gonna believe me, I'm as surprised as you are that I'm saying this. But if we're going to pass this and make it meaningful for people to have that opportunity, why wouldn't we include the language in there that would encompass a time frame, not just the infraction, but a time frame subsequent to the the violation, so that if it was beyond that time with no other instances, that they would still have this opportunity to them. That's regardless of the infraction. Well, any violent ones, no. I would say that's where I would say. But like people like that were, have homeless and broke into a house because it was warm or something like that, that could be a burglary offense. But when you look at those, but if you have a violent offense, no, I don't agree with that. But some of these others where that's what I'm saying. That's where I'm at. I don't know what the thought is of the body, and I don't know how to craft that in about a 2-second fix here.
I fully agree with where you're going. I'm going to defer to Miles, because the governor, representing the governor, you brought here, and then also I know Senator Walsh-Ricker has worked a lot on this bill for a long time. I'll just say this: the product before you is the product of a months-long, maybe a couple of years actually of work and thought, and so I actually agree with where you're going, but I don't.
So my only request would be then is, because I see someone that comes down here who's passionate year after year after year, who's being re-victimized by this year after year after year, is a positive contributor to society, is trying to right things for mistakes he's made that are nonviolent in nature. I believe his was drugs, nonviolent in nature. And I would like to take the opportunity to sit down and at least just have a discussion with Senator Walsh-Ricker and Miles in between our voting session today to see if there isn't some way, if we can hammer out some language, great. If we can't, we can't. But I would like that opportunity if the committee is amenable.
So no, look, I mean, I'd like to advance the bill today, just given the timeline that we're on. I think everyone's going to be open to having those discussions, as the bill moves through this process, and if the committee is amenable, we'll talk about any amendments that, we can have that debate continually.
Well, the only concern I have about that is once it's going to move, it's going to get lost, and then we will not get back to having this discussion for this this one other niche of issues that we're seeing in the system.
Get folks together, and then if you have a product, then we will convene the committee. I mean, even if you have to pull them off the floor, go in the back, whatever, go in the silver room. We're not going in the back. Go in the silver room, Open Meetings Act, and have a discussion. But I'll promise you that if that's something that that you're interested in continuing to dive. But I don't want to slow the bill down. But go ahead.
And I just wanted to say, I missed this originally. I think I didn't catch what you were saying originally. To my understanding, I thought this did address some of the issues that Mr. Coleman was experiencing.
I don't think so.
Let's verify that.
I have.
Well, let's verify that if there's one.
Okay, cool. Can I say something else, please? Yeah. I'm good.
Who well?
I'm rubbing off on him.
I'm not going to.
I knew I shouldn't have went church.
Any further questions from the committee? So let's adopt the amendment, and then we'll continue the discussion. So motion to adopt the amendment's moved. It's been seconded. Is everyone okay? All right. Everyone's okay being reported in the affirmative. All right. The bill is now before you as amended. Further discussion.
I just want to support what my senator, what Senator Fulton said. If there's a way, I do agree with him, and I see him down here year after year, and if we can adjust it, I would certainly support what he's trying to do. And I want to work with and try to figure out how to do this.
Before we vote on this, the last thing that this does is it changes, the one key component is that you don't have to satisfy the terms that it's a completion of the sentence. And I will just, that is a concern, like that we've removed, that you have to satisfy it. We've bracketed out the and component where it was going to require them to have paid monetary restitution, and now that's not a requirement either. It's in consideration, but it's not a component of and, it's now a standalone or. So because of those reasons, I will let you know that's those two things, I will be voting against it because we've removed a component that while I'm about restorative justice on this, like you should still have to.
Do restitution.
Right, the restitution is important. I understand, but we're codifying it in law that you could be an or, and that's not okay for the victims.
Still a factor, but also, I mean, if you're, so I don't practice in this, I'm not a criminal attorney, but I mean, my understanding is, and if you all want to come and provide some color on this, but a lot of this stuff doesn't get, for people that can't afford it, I mean, it doesn't get,
Yes.
It will never be satisfied anyway.
And that's in here, though.
Yeah, I know.
That component's in here, so the bracketing out of the and is not necessary according to that, because it's already allows for if the, does not have the ability to repay the restitution if they're indigent. That latitude's already given to the court.
Yep, I'm with you. I don't like that part. That isn't part of what the problem is.
Discussion.
I'm giving you that restitution.
Yeah.
Senator Sidner.
Right.
Could I be put down as a co-sponsor? Thank you.
All right, I have Senator Sidor, Senator Waltrigger, and Senator Smith as co-sponsors. And Senator, I'm sorry. Okay. Henson Love. Senator Hughes.
All right, so is everyone okay adopting the sponsor amendments? Yes. All right. Now the bill's before you as amended. Do we need a roll call? Okay. So everyone but James is down.
The reason that I tried to work with staff about the restitution
Yeah.
issue. I think the problem that we're trying to address, we have done, but why the bill went beyond that, I don't know. And I just couldn't get, it's not blaming them. There was no resolution to the restitution issue, so.
All right. Senate Bill 432 passes what? 92. With amendments. All right, we're now going to go on to Josh, to Senate Bill 600.
Senate Bill 600 authorizes for 5 years the use of stop sign monitoring systems on state and local highways in school zones in Baltimore City, similar to an existing authorization for Prince George's County. You have two amendments in your packet. The first is number 503-527/1. Both amendments are from the delegation. That amendment simply adds the phrase pilot program to the short title of the bill. And the other amendment in your packet is number 843-223/1. This amendment limits the program to the 45th Legislative District and requires that 50% of the revenues from the systems go to the local management board in Baltimore City for youth programming in the 45th Legislative District.
Are these amendments? Yeah, well, I've got to say, after the colloquy I had the other day with the sponsor of this bill, remember, this is a Baltimore City delegation bill. My bill was a Baltimore County delegation bill. I am tempted to be obstructionist, but I'm not going to do it. I just want that to be on the record.
Right.
Everybody needs to have a theme in the rest of them, right?
Yeah. Can we- All right, can we adopt the amendments? All right, all right. So motion, is there a motion? All right, motion second, is everyone okay? All right, everyone's okay being recorded in the affirmative for the amendments. All right, now the bill's before you as amended. Is there further discussion? Do you need a, all right, is everyone okay being recorded in the affirmative? Right. So. Yeah, is everyone okay being recorded in the affirmative on this bill?
No, I don't want
Yep. Yep.
Baldwin's down,
I'm consistent.
Baldwin's down.
So bill passes 9-2?
Yep.
All right, with amendments?
Person across the room.
I know, right?
The Baltimore City, 600 schools. Says 600. Stop them right
Yeah, we're gonna finish this list. Don't worry, we'll get to it. We'll definitely get to it. Josh, are you ready for Senate Bill 765?
Yep.
Okay.
Senate Bill 765, as drafted, requires the Department of Human Services to adopt regulations setting the maximum number of children that may be placed with an out-of-home placement provider, which would not apply to a child enrolled in higher education under certain circumstances. There is an amendment in your packet, which is number 263829/1, which instead of requiring the department to adopt regulations, would instead allow individuals who are attending higher education or vocational training programs to remain in an out-of-home placement during a break in the educational program or permanently if the local department approves of that arrangement.
1 second. I don't have it either. 1 second. So we're going to go on to Senate Bill 80.
This bill increases the penalties for abusing or neglecting an animal under 10604 of the criminal law article if the violation results in the death of an animal or need to euthanize the animal based on the recommendation of a licensed veterinarian. The bill also allows a court to prohibit the defendant convicted under 10604 from owning, possessing, or residing with an animal as a condition of sentencing.
Okay. Ooh.
Just received a question about the fiscal impact. I do want to note for the committee, in year one, there's approximately $124,000 fiscal impact or expenditure. For the next 4 years, those numbers appear to be around $100,000 a year. That appears to be mostly because of costs incurred by Maryland Department of Agriculture.
So just, I know that we have a threshold, so I know that's above our spending threshold, obviously given their austere budget times. So this bill is going to have to be heavily amended to fit into those constructs. I have some amendments that I'd like to offer. So look, I mean, if you're looking to deter this type of activity, we could just, you could increase the penalties, but, which this bill.
Could you put me on, Steve? Yes, sorry. Thank you, Mr. Chair. Right, so for a first violation, the penalty would remain the same. The bill is drafted, which is 90 days or a fine not exceeding $1,000 or both. However, for a violation that results in the death of animal or need to euthanize the animal, that would go up to not exceeding 3 years or a fine not exceeding $5,000 or both.
I mean, you see, like Chris, like the bill is drafted, permits these penalties on the recommendation of a licensed veterinarian. So you can go to, a state veterinarian. You could go to jail for 3 years because a vet says this dog or animal has to die. Jamie, can you give me the definition of an animal in the code?
Animal? Yes.
Oh, it's pretty broad.
All right, listen, you go to jail for 3 years, the vet.
So an animal is defined under that part of the law as any living creature other than a human being.
For 3 years.
Other than plants. You went to do science around and stuff. Peter will run.
All right, just listen to the definition of an animal.
Sure. Let me make sure that I've got it right.
So veterinarian says this animal is not creature. It's animal in the statute. Has to. So go ahead. Listen.
Right. Let me just pull this up. 10.6. So under 10.601 of the criminal law article, an animal is defined as a living creature except a human being.
So you want to go to?
Oh, living. So then you went to plant? That's a bad definition.
So, Mr. Chair. I just want to make sure, if we put this out for everybody to hear that a creature could be a cricket, an ant, anything that your kids are playing with, that they decide to tear the legs off of a cricket, which I don't condone. However, if you have that would fall under this definition. Counsel? The answer, you know the answer. I walked you right there. You know the answer.
It's a yes or no.
It's a yes or no.
I believe so, sir.
So this bill is actually about ants. It is actually about ants. All right.
I expected to get a Nick Charles answer, maybe, but I'll take that.
All right. So if just in the let's just play the hypo game, Jamie or counsel.
Just so you know.
If I kill an ant under this,
Bill's about ants.
I guess you have to have the recommendation. You have to have a veterinarian. What about a hamster? What about a hamster? Jamie.
So I do want to be clear about what the prohibition is under 10604. On page 1 of the bill, you can see that in subsection A, the prohibition is that a person may not, there's a list, 1, overdrive or overload an animal, 2, deprive an animal of necessary sustenance, 3, inflict unnecessary suffering or pain on an animal, 4, cause, procure, or authorize an act which is prohibited under 1 through 3 that I just read. 5, if the person has charge or custody of an animal as owner or otherwise unnecessarily fail to provide the animal with 1, nutritious food in sufficient quantity, 2, necessary veterinary care, 3, proper drink, 4, proper air, 5, proper space, 6, proper shelter, or 7, proper protection from the weather. So to answer your question, Mr. Chair, I think that in the case where a person engages in that activity and it does result in the death of the animal or the need to euthanize the animal, then under the letter of the law, you would be correct.
Would a worm that's being used for fishing?
So I think that inflicting, if it was unnecessary suffering or pain of the animal, I don't know that it would, because it is necessary for an activity that, you know, is commonly done. I would really need to look into that more for you. I'm sorry, what?
Animal research done in Maryland.
Again, I think that the argument would be is that that's necessary for an activity that is commonly performed.
Senator James.
I do want to just bring up an issue. You can decide for yourself how you feel about it, but Maryland is home to an incredible amount of research for the benefit of humans, both in the military and at non-military places. Aberdeen Proving Ground comes to mind just because it's in my district. So there's an enormous amount of research done on animals. You know, if you already don't want any of that happening, you can certainly go with this bill, but I think you want to bear in mind whether this bill is so broadly drawn that we might be ensnaring things that have enormous value to us, and that the bill is not really quite the way it ought to be to protect some simultaneously important issues that go on in the state of Maryland for the benefit of everybody in the United States.
Why don't we go on to the next bill?
Is that the will of the committee? Okay. Can you say it on mic, please?
I'd like to make a motion to hold the bill so we can get these further answers and not take away any more time.
Okay. No, honestly, in all seriousness, no, like the bill is very broad, and I mean, I think giving that power to a veterinarian, I think probably we have a serious issue to address. Animal abuse is obviously very serious, and I just think that the way that the bill is drawn, I think the committee has come to that conclusion. It's a little too broad, but we'll continue to work on it. Obviously, the committee is very sensitive to animal abuse, does not condone that in any form or shape or fashion, but the bill as drafted is a little too broad. All right, I appreciate the committee's work on that. All right, we'll now go on to 7. Can we go back to, does everyone have it now? Okay, let's go back to 5.
So just to recap, the bill as drafted would require the Department of Human Services to adopt regulations regarding children in out-of-home placements who are attending higher education or vocational training. The amendment, which you should have now, which is 263829/1, would strike the requirement for the department to adopt regulations and would instead provide that an individual attending higher education or a vocational training program would be able to remain in an out-of-home placement during a break in the program or permanently if the local department approves of that arrangement.
We're just waiting. For the reprint to come on out, but if you could speak to the amendments.
How are you doing? My name's Daniel. I work in the Office of Government Affairs for the Department of Human Services. So we worked actively with both sponsors, or the sponsor for SB 765 and also Delegate Griffith in the House for the cross-file, and tried to get at what their original intention of the bill was. The original draft had a reference to children, which, as you know, is those aged under 18. So we had to change that since most college kids are not 18 anymore. And then the requirement to promulgate the regulations didn't entirely make sense because we don't oversee some of the out-of-home placement programs like RTCs that are under, health regs. And we actually promulgated regs for resource homes and kinship homes in December that would essentially do the same thing. So we just tried to amend it in a posture that the sponsors wanted, and both of their offices approved of it, and it gets at what they originally wanted, which is just if you're in out-of-home care and you go to a higher education or vocational training program like Job Corps, and during a break you would like to go back to your original placement, there's a mechanism now for them to request that and for the department to be obliged to answer them in a timely manner and try and make those arrangements.
This would be applicable to a foster care placement. Would the foster care parents still be compensated while the child was out of the placement?
So no, it would depend on the placement, but if it's, say, a resource home, which I think is kind of what you're referencing, no, they wouldn't count against their bed count if they were in college. They would be there, but when they returned, they would, yes.
So what if they don't have space?
If they don't have space, and that's why the time frame's in there, we can try and make arrangements for that to be the case. The sponsors wanted this to apply to all of our different types of placements. So it would vary. With a resource home, it would probably be difficult if they didn't have the space. But we would know it's something that they would want to do going forward and try our best, whether it's, in advance. There are mechanisms where we can pay for them to hold the bed. It's something that we typically don't want to do if we can avoid it. But to answer your question, if there is no space, there's no space. We have to be in alignment with federal regulations and requirements as well as our own. So if there's no space, they wouldn't be able to return, unfortunately.
Does the wording of it give you that flexibility?
So it gives us the flexibility to do it in a way to exhaust every option possible to us, to try and make sure that it's possible. It's really important to us that there's a certain standard for where we place any of our youth, and we don't want a scenario where there is no bed available if they're sleeping on the floor or something like that. For summer break would be obviously unacceptable, I think, to everybody here. So if there is no bed available, they would not be able to return to that placement.
And so I'm clear, as worded with the amendment, it gives you the flexibility to make sure that there's an adequate room for the child going back on placement.
Absolutely, yes.
Okay, thank you. Thank you, Mr. Chair.
All right, there's been a motion to move the amendment. It's been seconded. All right, now the bill's before you as amended. Further discussion? Second, is everyone okay? So there's a motion for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? That's right. Thank you very much for your explanation. We're going to go to Senate Bill 834.
Senate Bill 834 establishes that a manufacturer, distributor, or factory branch may require all dealers to include freight or dealer processing charges in the prices listed on a dealer's website, and may not take an adverse action against a dealer for disclosing on their website that the advertised price of a vehicle is the manufacturer's minimum allowable advertised price, and that the dealer may offer a lower price for the vehicle.
This motion for favorable and seconded. Senator West has a question.
Thank you, Mr. Chair. I'm not going to oppose this bill, but I just want to make the statement on the record that this is this year's annual Fitzgerald bill. And my problem with the annual Fitzgerald bills, which we receive every single year, is that he controls a group of dealerships which he owns. And when he brings these bills to us, he seems to make no attempt to secure the approval of any other dealerships to his bills. So it's almost as if we're legislating on behalf of a single businessman who owns property in the state and has a business in the state. I would feel a lot more comfortable in the future voting for these bills if he went out and talked to his fellow dealers and got some support outside of his own business for the bills that he brings. This bill is not as offensive as ones in prior years, and so I'm not going to vote against it. But I hope the message goes back to Mr. Fitzgerald that when he comes back next year, he really ought to come with some support from other automobile dealers around the state. Thank you.
Thank you very much for that. So there's been a motion that's been seconded. Do we need a roll call, or is everyone okay being recorded in the affirmative? Okay. Senate Bill 834 passes unanimously. All right, so Senator Folden, we're working on Senate Bill 874, okay? It's not ready, but we're working on it. And then also, just for the record, we'll have the salary bill for tomorrow. Okay. And then Senator Muse, we're still working on 649. This apparently, and okay. So apparently this problem, the testimony that it was that it was unique to Prince George's County. The testimony was that it was unique to Prince George's County for your 649 for this expungement of this no finding, which is I think it was an anomalous entry that this one judge was entering in. Apparently I don't know what they called it in Baltimore City. No verdict. No verdict was what it was called in Baltimore City. Apparently it happened there as well. So we're still working on some details of it, but it's most likely going to be like a summer study because it's a broader issue. But we think we have a creative solution for it. So, which mimics what we did with I think was that your bill, Senator West, a couple of years ago, with the alternate PBJ. Yeah, that was your bill. So. I think it has to go to summer study, but it's because it's a more pervasive problem than we thought. But also, we're still working out the kinks of applying this kind of new PBJ to this. No, it would be applicable to two jurisdictions, at least two jurisdictions that we know of, instead of just one. And then, so Senator Folden, we're coming back. I think we could fix this by tomorrow, 874. And then, all right, let's go to Senate Bill 207. That's Josh.
Senate Bill 207 is a departmental bill that expands a list of circumstances under which the MVA is required to revoke an individual's driver's license. It additionally states that if an individual's license is revoked under those circumstances, the individual is not authorized to file for reinstatement until 5 years after. And finally, the bill as drafted expands mandatory participation in the ignition interlock system. So you should have an amendment in your packet, which is number 823028/1. The amendment does several things. First of all, it removes the requirement that an individual's license would be revoked for probation before judgment. So it would still require a conviction for the revocation. It would clarify that the required revocation for someone who's convicted for a failure to remain at the scene of an accident would apply only if the accident causes serious bodily injury rather than simply causing injury. It would allow a reinstatement application after 2 years rather than the normal 5 years that's being created by the bill. If the MVA determines that not allowing an earlier reinstatement application would cause undue hardship to the individual, or there are extenuating circumstances that would justify the earlier reinstatement. And finally, the amendment would remove from the bill the provision that expands mandatory participation in the ignition interlock system. There is one very small amendment to the amendment that is necessary just on further discussion with the administration, and that is on page 3 of 5, down in the unnumbered subparagraph 2 there, where currently it reads for this earlier reinstatement application, it says that the administration has to find after a hearing that there's undue hardship or extenuating circumstances. For technical reasons, it makes more sense not to say after a hearing because that typically means a hearing before OAH, and the idea here was that MVA makes that initial finding that an earlier application is justified, and then there would be the actual reinstatement application would go to OAH for a hearing. So just striking that phrase after a hearing in the amendment would be the only additional amendment.
Thank you, Mr. Chair. Josh, I just want to be clear. When I look at I want to make sure I'm reading what you're saying correctly. So in subsection 2 on page 2, where we're talking about 21-902, the A, B, and C and D portions, it talks about the death or life-threatening injury of another. Then we go to the next section, and it talks about the death or bodily injury. Is that where you're saying that they added in the word serious, or they?
Yes, they're adding in the word serious.
And can I ask why that addition was made?
I think it was simply that there may have been some unease about requiring the revocation in every case where someone left the scene of an accident that resulted in injury. So the idea was to require something a little bit more than just any bodily injury.
And then, but I guess my question is what's the standard of serious bodily injury? Because in the first part, you have life-threatening or death under the influence, but then the section 3 would not require an impairment, but just fleeing the scene of a crash?
Yes, it would not require impairment, but it would require the serious bodily injury.
So if you leave the scene of a crash knowing someone is injured, then we have a subjective standard of serious bodily injury because serious bodily injury is not defined in the code?
I know it exists in other places. I would have to look to see. I don't think it's defined, but I believe there's case law. I'd have to look into that. It is.
And again, I'm sorry, the concern was about serious bodily injury versus bodily injury. And what was that again? You just, if someone was injured, they didn't want it to be just like someone got their arm hit by a mirror or something.
Right. It just kind of raises the standard for when this would apply.
Okay. But Jamie, did you think the serious bodily injury was there?
Yeah, so there are a couple of different definitions in the code: serious physical injury, serious bodily injury. Generally, these all relate to things that are maiming or disfiguring, loss of a limb, or particularly life-threatening, versus general physical injury, which could be just general.
So like a leg
physical
break
injury.
wouldn't fall as a serious bodily injury?
It depends on which definition is being used in the statute.
Yeah, that's my point.
So, and in fact,
That's my point.
in 20-102, which is the failure to remain at the scene of an accident, there is a definition, which is an injury that creates a substantial risk of death, causes serious permanent or serious
Yeah.
protracted disfigurement.
Yeah, 21-902 involves impairment though.
Right.
So when you go to 20-102, which is what I'm referencing on for the article for failure to remain at the scene that results in death or bodily injury. So the standard is not impaired then.
No, you would not have to be impaired to get the
Under
revocation for.
2102, which you might actually cognitively know or reasonably expect to know that you struck someone and they would be injured, whereas if you were impaired, you may not be aware.
Right.
Okay,
Correct.
thanks. You want me to keep talking? Keep talking.
You need to adopt first.
Okay, can you,
Yep, here you go. Read it. If you can read my handwriting.
all right, so then we're going to adopt Amendment 82302811. Is everyone okay adopting? All right.
And then working off that, here's the second amendment.
What was the second amendment?
On page 3,
Yep.
subsection, what did I write, 6(2), strike after a hearing.
That would be my typo.
Yeah.
Oh, hearings. Okay, got it. Okay. Who caught that?
Well, that's not what's.
Okay.
It's convenient for me.
It's convenient. That's awesome. Okay. So page 3, section 6, line 11, strike after hearings. All right. So Roman 2, so section 6, Roman 2, if you go to the last sentence of Roman 2, you're striking after hearings? After a hearings? All right, is there a motion to adopt the amendment? Everyone's okay? Everyone's, okay. It's been seconded. Everyone's okay? Adopt the amendment. All right, is there a motion? It's a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 207 passes unanimously with the amendments. All right, we're going to go with Senate Bill 586.
Senate Bill 586 repeals provisions of existing law that require all assets owned by any Methodist church to be held in trust for the United Methodist Church and subject to the discipline, usage, and ministerial appointments of the United Methodist Church. There is an amendment in your voting packet. This is Amendment 173520/1. The amendment establishes a new provision that provides that a local church may disaffiliate from the United Methodist Conference and retain ownership of its property, subject to the following provisions. First, a disaffiliating local church shall reimburse the United Methodist Conference for financial investments made by the conference for the acquisition, maintenance, or improvement of real property used by the local church in accordance with subsection C of this section, which provides, first, the United Methodist Conference shall provide a disaffiliating local church with a full and transparent accounting of all funds the United Methodist Conference has contributed for the acquisition, maintenance, and improvement of the real property used by the local church from which the amount of the reimbursement required under B shall be determined. Second, a disaffiliating local church may not be required to reimburse the conference for any amounts attributable to financial investments for the acquisition, maintenance, or renovation of real property made by the local church.
That provision that says all property is held in trust, in a sense became obsolete when the General Conference makes the laws for the entire church worldwide. They did give 3 ways to leave the United Methodist Church. So that made that held in trust, in a sense, irrelevant because they gave them 3 ways out. And many of the conferences, and a conference is defined as that jurisdiction that a particular bishop is in charge of, most of them let the churches out for nothing. Only in the Baltimore area did they say, if you want to leave, you have to give 50%, pay 50% of the worth of your building, and you only have this much time to do it. Some of these churches are 1 and 250 years old. The congregation is a lot older. It was a way of keeping them. What the bishop said, was 2 things. They said, we put money in these churches, and she said, I want to keep that provision. This becomes a win-win because you can keep that provision. All those who want to stay, the property is held in trust by the Methodist Church. However, if the Methodist Church never put a dime into the church, if the Methodist Church did put some money in, then they have to pay the Methodist Church back. And so that provision stays, and the people who want to leave, not just by virtue of General Conference, but by virtue of this going into the statute, it allows them to leave without being, and these are my words, raked over the coals. And so it's a win. It becomes a win-win. Those that remain, that provision is still efficacious. That property is held in trust. Held in trust simply, again, means if it's not used for United Methodist reasons. And then lastly, what is happening is that many of these churches who cannot afford to pay up to half of their, if it's a $6 million church and you've got to give them $3 million, you do that on top of your annual assessment each year, which is in tens of thousands. So what this basically does is to say, number one, as I said, you're able to maintain the property. Those who remain, that property is still held in trust. But a number of churches are being sold off today. A number of these churches where people cannot afford to pay off their church, but they want to disaffiliate, the option is the church is sold and all of the money is taken by the mother church. Nothing is given them. Not just the building, but the money in the bank, dishes, everything there goes into the Methodist Church. And that's what the fight has been over since they made the decision that you can leave. And in various conferences, bishops have decided you can leave with your property. And others have said you can leave if you pay 5 years of your assessment. This is the most stringent, and again, it becomes a win-win.
Thank you, Mr. Chair. I have in my notes that there's a pending lawsuit right now. Does anybody know the status of that lawsuit and whether we would be weighing in the middle of a lawsuit?
We would not be, there are lawsuits all over the country. So these lawsuits are not just specific lawsuits that would affect, the people are suing to either maintain their building or get out, but that's all over the country. There's no one law that would change what we're doing or that would, in any way impact it, so no.
I'm sorry, I'm not quite sure.
If I'm a local
following. So
church,
there's a lawsuit pending in Anne Arundel right now over this. And I thought we had sort of a general hesitation about weighing in with legislation when there is a pending lawsuit.
There will always be independent local churches suing. I don't know what they're suing over. If they're suing because they want to leave, this gives the judge at least an option of saying you can leave as opposed to saying with this statute you absolutely cannot leave. So it just gives that option.
Okay, I just want to make sure we're not putting our thumb on the scale one way or another of
The
a
thumb
pending
is already
lawsuit.
on a scale by the state, and what the state has said is that the property is held in trust and you cannot leave. Judges have said, I've seen, and some of them came down, they said, if I had a different approach, I could at least use my discretion and say, yes, you can leave because A, B, C, and D, rather than saying, no, you cannot leave by statute. That statute went in by Marvin Mandel, who did come down to testify in the hearings of before he passed, and I have that letter in the file, in which he said, and I quote, "It was the worst thing that I've done in terms of separation of church and state, because now the state is involved in saying to churches, you must worship a certain way, you must remain in this church," and it said it was just the wrong thing to do. So if anything, it gives judicial discretion to a judge to make a decision on individual cases based on what they may want to do.
I hear your argument, but
Right.
the fact of the matter is there is a pending lawsuit
All over the
based
country.
on, well, I understand,
Right.
but I'm talking about Maryland. Based on current Maryland law, and that's what lawsuits are brought on, current law. And so we are coming in the middle of a lawsuit and making a statement about the law as written. So we are affecting a pending lawsuit.
Well,
And
I don't know. When we
that is
passed-
concerning to me.
When we passed this before, out of this committee, there were pending lawsuits. My point is.
We haven't passed this bill.
No, we passed it. I mean, when I say we passed it, this was before your time. We did pass it out here, and it passed out of the Senate, and there were lawsuits all over the state of Maryland. This does not say to a judge, you cannot do A, B, and C, D. It says at your discretion, you can rule a certain way. That's why we're leaving in place those same words, that the property is held in trust by the Methodist Church. We're not taking that out at all. We're simply adding that unless you have financial debt to the conference, if a judge so decides, you can leave. Judges have said it in testifying before that I want to do A, B, C, and D, but this statute keeps me, I can't move with this. And so it just gives that discretion.
That's my point. Thank you.
Okay.
As I'm reading, I just want to make certain that I'm understanding C2. All right, so within B, it says that the disaffiliating local church shall reimburse the conference for financial investments made for certain things in accordance with subsection C. Is the point of C2 to say that they can, but they're not required to? Is that how it's to be read?
The intent is if they owe money, they have to pay it back.
Senator Sidnor, I guess, just want to make sure I'm getting the question right. So C2 provides a disaffiliating local church may not be required to reimburse the United Methodist Conference for any amounts attributable to financial investments for the acquisition, maintenance, or renovation of a real property made by the church. So my reading of that is that where the local church is actually the entity that made those financial investments, they would not be required to reimburse the conference for those costs because they were made by the local church.
Okay. They most likely pay for the improvement, and that's why improvement is in B, but,
If they pay for the improvement.
okay, okay. Thank you.
I'm sorry, Mr. Chair. I just wanted to go back to the colloquy that Senator Muse and I were having. As I read this language, this is not giving the judge discretion. This is saying a local church may disaffiliate and retain their property. They shall reimburse the conference for financial investments made by the conference, and the conference shall provide a disaffiliating church with a complete accounting. So it's not saying, Judge, you can think about this. It's saying they shall. So just to make sure we're clear. Thank you.
During the testimony, I asked the overall bishop, could she give us some examples of where the mother church paid for a roof, a furnace, whatever. If you remember, she said she had that. The people, we actually had to say to the audience that they should not yell no. And to date, she has yet to give us a single piece of information that says that the mother church paid for a roof, HVAC, nothing whatsoever. So I do not believe we're putting on the scale in this. We are actually righting a wrong that should never have happened in 1972. And with that, if it is appropriate, I'd like to move the amendments. With that being, I'd like to move the bill, please, as amended.
With the amendment, it's been seconded. Do we need a roll call, or is everyone okay?
No, I'm in the negative, based on the conversation, which I brought up during the hearing, and I believe that we're going to run afoul of the Maryland Constitution in doing this.
Do you want to?
We're doing the attorney's opinion.
Yep.
Well, I've read earlier Attorney General opinions that have already ruled on this, but perhaps the law has changed since then.
All right, welcome back to the Judicial Proceedings Committee. It is Wednesday, March 12th, 2025. We are now on voting list number 13. But before we proceed to voting list 18, we're going to all right, that's fine. We're going to go back to Senate Bill 80.
Would you like me to?
Yeah, so council's going to tee us up.
So Senate Bill 80 is the animal abuse or neglect bill that the committee was considering during the last portion of the voting session. At the request of the chair, I have gone through the bill and attempted to address some concerns and with the guidance of some of the members. There is no amendment before the committee, but going through the bill, the amendment to Senate Bill 80 would be to alter the existing prohibition or add to the existing prohibition by providing that a person may not, just to refresh the committee, the existing law provides a person may not overdrive or overload an animal, deprive an animal of necessary sustenance, inflict unnecessary suffering or pain on an animal, cause, procure, or authorize an act prohibited under item 1, 2, or 3 of this subsection, or if the person has charge or custody of an animal as owner or otherwise unnecessarily fail to provide the animal with nutritious food in sufficient quantity, necessary veterinary care, proper drink, proper air, proper space, proper shelter, or proper protection from the weather. The new language would provide that a person may not commit an act prohibited under item 1, 2, 3, 4, or 5 of this subsection that results in the death of a domestic animal. The bill would further provide with respect to penalties that for a violation of subsection A1 through 5, which is the existing law, which does not require proof that the animal died, imprisonment not exceeding 90 days, or a fine not exceeding $1,000 or both, which is the existing penalty. For a violation of subsection 6 of this section, which is the new language that I just read to you, imprisonment not exceeding 3 years, or a fine not exceeding $5,000 or both. The bill would retain its provisions that as a condition of sentencing of a defendant convicted of violating this section, the court may prohibit the defendant from owning, possessing, or residing with an animal for a period of time determined by the court. And as a condition of probation, the court may prohibit the defendant from owning, possessing, or residing with an animal for a period of time determined by the court. And part of that is existing law already.
Thank you, Mr. Chair, and thank you, Jamie, for working on this. Quick question. Domesticated animal, would that include horses?
So there's a bit of a question about whether domestic and domesticated, the word that I used in the marked up copy that I prepared was domestic animal,
Okay.
Which I would define, and I can look to see if the code specifies this, but I think you would define as an animal that lives inside of a house. A domesticated animal, I think, would be broader and would include things like horses or cows. Livestock, I think, would be domesticated.
Then I would prefer domesticated.
Senator Foley.
I'm sorry. Did you say that you would prefer domesticated? Because,
Yes. Horses.
but but that would cover, under your opinion, Jamie, then domesticated. Because when I looked up, domestic animal is an animal that has been tamed and lives with humans.
Right, I think and lives with is the critical part of that definition.
And then domesticated
would be a much broader category of animals.
to include
Which I believe would
domestic animals.
probably include
To
not only
include domestic,
domestic
like-
animals, but also livestock.
Yeah, okay. All right, thank you.
Probably sheep. I mean, maybe.
Yes. It would have to do with that. So dogs, cats.
You just say okay.
Thank you, Mr. Chairman, I apologize. I was asking about domesticated animals, and I do really share Senator's love for horses, because I love them too, I think we talked about it. But I am wondering, I think I want to have a full understanding of all the animals that would be included, and because we have enormous livestock farms in Maryland, including chicken farmers on the eastern shore, so I don't include sheep, donkeys, llamas, cattle. I could go on, but there's a good set right there. Yeah, just so we can get some clarification, I would appreciate that. Thank you.
And Senator, just to sort of answer part of your question.
Yeah.
There are existing parts of the code where there is a reference to, so pets are defined in different parts of the code.
Okay. Pets.
So pets are defined in various parts of the code.
Right.
And I have one definition here under the family law article that a pet means a domesticated animal.
Interesting.
But within that definition, the General Assembly took the extra step and said a pet does not include livestock. So it was.
Yeah.
It's a line that I think has been delineated to some extent.
Right.
But.
And I don't know, sorry to interrupt, but I do not know, it's so good that you look at the definition, so I think it's really helpful to us. So I would like to know if we have definitions for domesticated and domestic animals, and you obviously just told me we have a definition for pet that does include domesticated animals, but also excludes livestock. Is that correct?
Well, right, so
At least in the family law article.
So the way that I'm seeing it is that the term pet is where that's the operative term that's being defined in those
Right,
sections.
right.
And then pet is defined as a domesticated animal. So it wouldn't need to live in the house.
Right.
But it would need to be something that had been tamed, I suppose, but not a wild animal.
Right.
But the General Assembly took the additional step to say, just to be clear, that does not include livestock.
But I'm just saying that definition then blurs our kind of understanding here because we're talking about domestic and we're kind of
Right,
thinking.
without an exclusion to livestock,
Right. So we should take.
I would think that saying domesticated probably does include livestock if you're just full stop saying domesticated.
Right. Well, thank you for taking a look at this. So you'll get back to us. Thank you.
Okay.
Okay, so look, I mean, we know that the term animal is in the current statute, which I think this part of the statute is inartful at best, because the definition of an animal is what? Is any...
A living creature.
A living creature other than a human being, which is a broad definition. And the fact that we're going to give the ability of two veterinarians in this bill, if it's a livestock or agricultural animal, to be the arbiter as to what, whether someone goes to jail for 3 years. Obviously, we have an obligation to take this very seriously, and so I think the amendments that were before us, which I hope we adopt, and we can work off of them, as we do more work tonight and tomorrow morning, greatly improve the bill. And obviously, every member of this committee wants to protect animals from animal abuse, and wants to make sure that that's not something that's prevalent in our state. And so I thank the sponsor for his work, and I thank the committee for their work. We'll continue. I think we're going to get a good product out of this, but just because of the overly broad nature, because you're going to send someone to jail for 3 years for a definition that includes every living creature that's not a human being, and because it leaves that decision up to a veterinarian, I think we have an obligation to take that seriously before you throw someone in jail for 3 years. So I'm glad we're working on it. Senator West.
Just let me, in order to add some context to this, I think we earlier concluded that animal includes mosquitoes, flies, ants. Okay, thank you.
Yeah, thank you for that. I mean,
Well, they're living creatures.
living creature. So, okay. So now we'll move on to Senate Bill 396.
Now on voting list 13.
So we're going to Senate Bill 396 on voting list 13.
So Senate Bill 396 is a bill on which this committee is secondary to Budget and Tax. They voted it out this morning as amended by Budget and Tax, and the amendment number, which should be in your packet, is 563125/1. That was adopted by Budget and Tax. Essentially, with the bill as amended, the bill does two things. First of all, it adds 911 specialists to the list of public safety officers who are eligible for death benefits if they die as a result of injury sustained while on duty. And it additionally creates a presumption that those public safety officers died by injuries sustained in the line of duty in circumstances in which the individual commits suicide after being diagnosed with PTSD or a similar mental disorder which was caused by their job duties.
All right, so we'll wait for the reprint to be delivered to your desk. It's on the list. We're going to, which one was that? It was number 4, but we can move it up to number 2, or number 1. So let's go to Senate Bill 721. Actually, hold on. We're going to that's the same council. He's got to print some stuff out, but we'll come right back to it. We will come right back to it. All right.
873.
Let's do 717 really quickly.
Senate Bill 717, Judicial Proceedings was secondary to Education, Energy, and the Environment, who gave this a favorable report. The bill increases salaries for certain public officials in Somerset County. The officials are the sheriff, member county commissioner, the president of the county commissioners, a member of the county roads board, and the president of the county roads board. Pursuant to the Maryland Constitution, these salary increases take effect at the beginning of the next term of office.
Sorry, motions for a favorable. Second. Is everyone okay being recorded in the affirmative? All right, excellent. Senate Bill 717 passes unanimously. We'll now move on to Senate Bill 721. Josh.
Senate Bill 721 alters statutory provisions that govern the issuance of a permanent protective order by specifying that an individual may consent to the issuance of such an order. So currently, the only situations in which a permanent protective order is authorized is where the respondent to the protective order was convicted for the underlying act of abuse or an act which violated an existing protective order. They were sentenced to at least 5 years for that act, and they've served at least 1 year of that sentence. So with the bill, additionally, you would be able to get a permanent protective order if the respondent agrees to it, consents.
By our state's attorneys who asked for it. One of the ways that they can get these orders, if you get it by consent, they can use it to plea bargain as well. If a person is convicted and then they're sentenced to 5 years or more and then 1 year passes, then you could get this. But if you say, hey, we'll allow you to plead to something lesser than a 5-year sentence because what we really want is for you to stay away from this person, and they agree to it, then they could do it under this bill. Without this bill, you would have to have that 5-year sentence. You would have to serve 12 months of it and or violate your order. So this gives the ability for the respondent to consent to the order instead of having to have that long sentence.
Thank you, Mr. Chair. I just want to confirm that the stipulation in the language of the bill, as far as if the respondent concurs, that the language is still included that the person requesting said measure would also be prohibited from contacting the respondent.
I don't think that's in any of our protective order statutes where it's a mutual, you can't contact.
No, I think, I'm pretty sure I think it is. If you swear out a protective order, you then there cannot go ahead and, I just want to, like, I wouldn't want this to be like one way and then all of a sudden the person then starts in what would be a violation by then going and contacting them, even though the respondent agreed to it, putting them in a trick bag, if you will.
Sure. Council will answer, but we're not changing anything about the existing
Yeah, I
protective
understand
order
that.
law.
I
It's
just,
only adding
okay,
consent.
all right.
Yeah, I'm not sure about that particular term of a protective order. So a permanent protective order can be rescinded by the victim. That's the only situation in which the permanent protective order can be dissolved. But I'm not sure about that particular kind of term in a protective order that you mentioned.
All right. It's a motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Senate Bill 721 passes unanimously. All right, we're now going to go on to Senate Bill 707.
Senate Bill 707 repeals the 2-year time limit on the medical exemption that allows the operation of a vehicle with enhanced window tinting in the state. There is an amendment from the sponsor in your packet, which was just handed out as well, which is 123025/1. And so instead of completely repealing the time limitation, it would specify that the certificate that you get from a medical provider is permanently valid if the medical provider verifies on the certificate that your condition is permanent. Otherwise, it would still be good for 2 years if the condition is not permanent.
I'd like to just move the amendment so we can work off the amended bill. All right, second. All right, now the bill's before you as amended. Further discussion. Bill's been moved, it's been seconded. Is everyone okay being recorded in the affirmative? Senate Bill 707 passes unanimously with the amendment. All right, now move on to Senate Bill 711.
So Senate Bill 711 establishes the Off-Highway Recreational Vehicle Recreation Oversight Board to advise the Secretary of Natural Resources on the operation, acquisition, regulation, and general oversight of off-highway recreational vehicle trails and recreation in the state. There is an amendment from the sponsor in your packet, which is number 593322/1. And this removes from the bill certain requirements for the board to review expenditures from a off-highway vehicle-related fund, and that would have set certain goals for the fund. So those provisions have been removed from the bill with the amendment.
All right, so the amendment has been moved, it's been seconded. Is everyone okay adopting the amendment? All right, now the bill's before you as amended. Further discussion. It's been a motion for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? Senate Bill 711 passes unanimously with the amendment.
We have that. That was a clean copy. It just passed 396. That's another.
Okay. Let's go on to, since we're on here, since you were second, all right, let's go to 396.
So again, Senate Bill 396 is a bill on which the Budget and Tax Committee was primary, Judicial Proceedings is secondary. Budget and Tax voted it out with an amendment, which you have, which is number 563125/1. So with the amendment, the bill does two things. First of all, it adds 911 specialists to the list of public safety officers who are eligible to receive death benefits. And it also creates a presumption that when a public safety officer dies by suicide after having been diagnosed with PTSD or a similar disorder, which was caused due to the nature of their job duties, that it creates a presumption that those individuals died as a result of injuries sustained in the line of duty, which would presumptively make them eligible for death benefits.
So there's been a motion for favorable on the amendment. It's been seconded, and everyone has been recorded in the affirmative on the amendment. Now the bill's before you as amended. Is there further discussion on the bill, on the amended bill? Been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Excellent. All right, we're now go on to Senate Bill. Josh, are we ready for Senate Bill 608?
Yep. So Senate Bill 608 was brought up at yesterday's voting session. As a reminder, it makes changes to the U non-immigrant visa process for certifying entities in the state. I think so, yeah.
What's the number?
608. Was it in the?
No, I don't think that's because we did that one yesterday, so we don't have that one. Unless the members kept it on their desk, which I doubt that they did. Yeah.
All right, while we're getting that printed, we're going to go to Senate Bill 43.
43, this is the bill that Finance is primary on, JPR is secondary. Finance voted the bill favorable with amendments last night, and Counsel for Finance Committee briefed the committee on the bill. And there's a copy of the reprint in your voting packet. The bill effectively authorizes the use of forensic review boards to make recommendations regarding release of individuals who are deemed not criminally responsible. So just to put this in context, these are individuals that have been through the trial process, and the court has determined that they would not be criminally responsible for the acts that they were found to have committed by reason of a mental condition. That's distinguishable from somebody who is incompetent to stand trial. That occurs on the front end of a proceeding where the court determines that a person is not competent enough to effectively assist in their own defense. So that actually occurs before trial. The state attempts to return the person to competency, and then if they are, the trial can proceed. That's a completely different procedure or proceeding than this. This is at the back end of things. There was a question asked yesterday about what that looks like on the front end of an NCR. And as it happens, one of the speakers from the Attorney General's office who was here last night used to actually do these cases and summarized it pretty succinctly. Essentially, it is a battle of the experts after the fact. The defense alleges that the defendant was not criminally responsible, puts forward a physician who evaluates the defendant and makes that case to the court. The state generally disagrees and has their own expert physician evaluate the defendant and testify to the court on that. And from that, the court makes a determination about whether the defendant was not criminally responsible. MDH is required thereafter, after a finding of NCR, to generally take custody of the defendant, and I believe they are required to place them within 10 days. Now, the procedure here is the Forensic Review Board is employed or works in these healthcare facilities that are treating individuals who are committed to them, and they make a recommendation to the court regarding release. And let's see. I'll just turn the committee's attention to page 2 of the reprint. At line 19, it provides, the Forensic Review Board shall, by majority vote of the members, determine whether to recommend to the court that a committed person is eligible for discharge or conditional release with or without proposed conditions. Each Forensic Review Board shall maintain a written record containing its findings and recommendations. The written record shall be included in the medical record of the committed persons. Right. Just to summarize, that's a recommendation that the board is making to the court.
I'd like to move the amendment, so just we're working off the amended bill. Is that everyone okay with adopting that? This is Milken for a second. It's been adopted. Senator James.
Wanted to clarify with him, the bill really inspired me to think about another issue, not so much to do anything with this bill, but I did, because of yesterday's hearing, not gather just why the bill was needed, I mean, really briefly, and it looks like this is all new language. So perhaps we had no procedure or not one as elaborate as this, and now we're creating one. But if you could just briefly tell me whether we really had just maybe one or two doctors, no formal process board, record keeping, analysis, and all that. And that's why we're doing this, you know, that we're formalizing it, trying to put some real wraparound to it, make people really pay attention to it, and keep better records. So if you could just tell me what we're doing now and what this is going to do to make it presumably better, right? Very briefly.
So my understanding from the bill file and from speaking with committee counsel is that in many cases this is already being done, and you're correct, it is a formalization of that process.
Okay.
And establishing rules for what the review boards sort of the guardrails or requirements for those review boards, their composition. So for example, I mean, it establishes the membership. Each forensic review board shall have an odd number of members, presumably because they're going to be voting on these things so that there are not tie votes. Each member shall have one vote, and a quorum is required. So it's establishing rules for what it sounds like is already in practice to some extent or in some shape already.
And there was just one way this bill intersected a little bit with Senator Quarterman's bill, which is that the very anguished victims, remaining family members of the 3 slain men out in Western Maryland, were, you know, re-traumatized because they get a notice every year. And it looks like that will continue. So my brief question to you again, I don't want to sideline this, is I don't see it here, but I assume that somewhere else in the law, they are notified of this. And I don't see it here, but I assume somewhere else in the law, they are allowed to make their opinions known. And if you don't know, because it's not in this bill at all, I'll stop the questioning.
I don't know. I mean, to be honest,
I'll figure it out.
This is kind of, I think, where the joint assignment came in, because it's, this is more on the healthcare side, but it does kind of loop back into what this committee's jurisdiction is,
Right.
which is the evaluation of by the court. There is a victim notification system
I'll try to
in
find
Maryland. I believe it's the VINE system.
It's what? Say that again.
I believe it's the VINE system.
Divine?
VINE. It's an acronym.
V-I-N-E?
V-I-N-E.
Very good.
But as far as notifications given to victims on the MDH side of things, now I know if we were talking about a parole hearing or
Right.
something where a person's being released potentially from incarceration,
Right.
there would be
An opportunity to.
I'm not entirely sure, since we're out of DCPS or DPSCS and into MDH, what the requirements are.
I just thank you for indulging me. We're not on this bill directly, but I thought maybe in this you might have seen something. Appreciate your answers, and I'll figure it out. Thank you.
All right. I'd like to move the bill if there are no questions, concerns, further discussion. It's been seconded with the amendments. Is everyone okay being recorded in the affirmative? Senate Bill 43. Are you good?
Yeah, my questions were answered. I spoke to the sponsor.
Okay, great. Excellent. So Senate Bill 43 passes unanimously with the amendments. We're now going to move on to Senate Bill 828.
Senate Bill 828 was discussed at the voting session last night, and there is a new amendment that was distributed earlier in the voting session, which is number 153324/1. So just walking through the amended bill, the reprint, The bill is essentially divided into sort of three parts. The first is beginning at the bottom of that first page of the reprint in the criminal procedure article. The amended bill would generally require that certain entities deny access to an individual who is seeking to access a non-public space for the purpose of immigration enforcement without a valid warrant or exigent circumstances existing. And specifically, and this is something that's new in the new version of the amended bill, this would apply specifically to a public school, public library, or a unit of the executive branch of state government that operates at a sensitive location. And just the definition of sensitive location is actually located later in the bill in the next part, which if you continue on the reprint to page 3 of 3 there, the new text in the middle of that page is the definition of sensitive location, which would be a public school, a public library, a healthcare facility operated by a unit of state government, a facility operated by the comptroller, a courthouse, or any other location that both provide state-funded services related to physical or mental health, education, or shelter care, and as determined by the Attorney General, requires special consideration for immigration enforcement activities. Moving on to subsection B, and this is really where the second part of the bill starts, the Attorney General would be required to develop and publish guidance regarding immigration enforcement at sensitive locations. And you can see there, and this is unchanged from the prior version of the bill, essentially what the contents of that guidance would be. The Attorney General would also be required to develop and publish guidance regarding the rights and responsibilities of individuals who interact with federal law enforcement personnel acting to enforce federal immigration law. And then starting there on the bottom of that page in subsection D is really the third part of the bill, which is that on or before October 1, 2025, each public school, public library, and unit of the executive branch of state government that operates at a sensitive location would be required to adopt policies consistent with the guidance that's been developed and published by the Attorney General. And then finally, just on the last page, there's a couple things. It clarifies that the guidance and policies would not be subject to the Administrative Procedures Act. And the amendment also changes the bill from being an emergency bill to going into effect on June 1, 2025.
All right, so there was I know there were questions about the judiciary. We consulted with them, and they are off of opposition for this. And so, counsel, just to be clear, because there are really three different sections of this. That bill does three kind of major things. And if you could just help us walk through, I think that'll, if you address them in this way, I think that'll address a number of the questions that are forthcoming or likely forthcoming. So just if you start on page 1, I know you, thank you for the rundown, but if you start on page 1, so this piece, when you're subsection 2, B2, really deals with the warrant requirements. If you just flush that out, it's these locations, they're just sensitive locations, that the warrant requirement now applies.
The thrust of that provision is that public schools, public libraries, and units of the executive branch of state government that operate at those sensitive locations would be required to deny access to individuals who are seeking to enforce federal immigration law to those areas of the sensitive locations which are not generally accessible to the public.
Okay, so that's under the criminal procedure article. Then you're going to move on to the state government article, which is, because it's an interlineated copy, it's a little bit difficult to read, but that's on the third page of or the second page, which starts at the state article. So you skip over to page 3 of 3, and right under line 11, this section, so all of these locations here, this refers to the guidance that has to be offered. So you can just explain that.
So the piece in the state government article is kind of broken up into 3 parts, which is 1, the definition of sensitive location, which is subsection A. Then subsections B and C both require the Attorney General to develop and publish guidance related to immigration enforcement at those sensitive locations, and that's directed at individuals. And then finally, the third piece is subsection D, which requires certain entities, specifically public schools, public libraries, and units of the executive branch of state government that operate at a sensitive location to implement policies which are consistent with the guidance issued by the Attorney General. So speaking to courts specifically, they are considered a sensitive location to which the guidance would speak, but because they are not a public school, public library, or unit of the executive branch, they would not be subject to either the warrant requirement or the requirement to adopt policies.
All right, so everyone understands that, so all of subsection A down, I mean, that's all policy, that's all guidance that's applying to them. So they don't have to develop policies and they're not subject to the warrant requirement. And then subsection D is the third part of that, where the policy applies to those entities. So I just want to make sure that everyone understands like the three buckets that that the bill is falling into. So Senator Sidnor first, then I saw Senator Henson, and then Senator West.
Thank you. Now, I was looking at the judiciary's, their opposition, and it seems as if they're attempting to make a constitutional argument. But I'm also looking at, and I'm sure, I don't know if you all received, but I've gotten an email from Rena Shaw of the Maryland Access to Justice Commission. Are you familiar with that?
Yeah, I did. Yeah, I'm familiar with her, yeah.
You and I are both.
She's great.
Okay. So, I mean, did you see her?
I did, yes, I did. So look, in an attempt to address both of those concerns, we did consult with the judiciary. Because they fall under this guidance, this guidance speaks to, they were fine with being incorporated in this fashion. And so it is our understanding, the judiciary is now off of that because the guidance just speaks to them. It doesn't require them to develop policies, and it doesn't require them to invoke that warrant requirement. So,
are they going to do that?
So, I don't want to speak for them, but I suspect that they will be looking into developing their guidance. I don't want to speak for the judiciary, but I suspect they will be reviewing that process.
Because this is just essentially talking about their facilities that we have a budget for and we fund, right? I mean, it's our building. I mean, they administer justice into this our building as well.
Well, I guess as a citizen of Maryland,
as a state, that's what I'm talking about. Right, that's what I'm saying.
But it's a separate branch of government, and so I want to obviously be sensitive to those arguments, to our structure of government.
Understand your bill.
Yeah, no, I hear you. Yeah. Senator Henson.
Thank you, Mr. Chairman. Not that anyone can, but I'm trying to keep up with the different things that are coming out federally, the threats of cutting funding. I know that our federal partners provide a lot of funding for students with disabilities. They fund our school lunch programs. They do a lot by way of Title IX and girls' sports. Have we gotten any indications if, I know certain things tend to trigger that threat of denying funding more than others. Do we know what this looks like?
Yes, so I'll be just candid in my conversations with the federal officials responsible for monitoring this, is that the U visa bill that we have forthcoming and this bill, the sensitive locations bill, would not trigger that type of interaction or repercussion. The more, and just in all candor, the more where the line gets close is the data privacy that we're looking into. And there's the data privacy, there's certain aspects of that bill as introduced that they are warning us about. And so we're still in discussions with that. But this bill and the U visa bill are non-offensive in that regard.
Okay, thank you for doing that research. I know our commitments to students that fall in those areas and need those programs are priorities as well. So I appreciate you doing the legwork.
Yeah, I just wish we weren't even in this juxtaposition. Yeah. It's a sign of the times. But Senator West.
Well, that was a very interesting answer. Thank you for that information. Because I'd asked some questions along those lines during the course of the hearings. I guess my question is, we do have the U.S. Constitution and the Supremacy Clause, and has our Attorney General opined as to whether this bill would in any way violate the Supremacy Clause of the U.S. Constitution?
So I'll the answer is no. We've not made an explicit request to evaluate this bill because it's been kind of evolving.
Sure,
but,
exactly.
I would just, so we've been working with the Attorney General on this bill and the language. So that's one thing, but we have not asked the Attorney General to opine on that. I would suspect, though, if there were to be an evaluation of this, or it would be with the warrant piece. And counsel, you can if I'm squinting towards the right piece of this, but proffering guidance and state policy could potentially, but I think it's the warrant piece and the policy piece that are probably the most subject. But I'll have counsel give answer.
Yeah, and I think it's difficult to say. I think there's been litigation in this administration and the last administration about the interaction of, the Supremacy Clause versus the 10th Amendment's anti-commandeering, which is really, I think, the core issue. And I don't know that there's been a really satisfactory resolution of that question, but that would be essentially the conflict you're talking about, is Supremacy Clause versus the state's inherent constitutional right to control its own policies and personnel. And I'm just not sure there's a final answer on that question.
I'd like to move the amendments just so we're working off of the amended bill. Is everyone okay with that? Motion for second? Okay. Further discussion on the bill. All right, make a motion for a favorable. All right, we do a roll call.
Vice Chair Waldstreicher.
Yes on the bill.
Senator Sidnor.
Yes.
Senator West.
No.
Senator Muse.
Yes.
Senator Folden.
No.
Senator James.
Pass.
Senator Henson.
Yes.
Senator Love.
Yes.
Senator McKay.
I'd like to say that this year, we are hit with a tsunami when it comes to fiscal policy, regardless if they were good decisions or they were bad decisions. And I will say that obviously the new administration has brought on some challenges. However, when the question was asked, how much money does the state of Maryland get? $14 billion. $14 billion. That is a possibility of being pulled, regardless if you agree with the administration or you disagree with the administration. I don't think it is good policy when we're already trying to bail out the ship with all taking on all this water to then have this as added on. We're going to sink the ship, and I am a no on this vote. Thank you.
Senator Charles.
Yes.
Senator James.
I'm going to vote no, and I want people to understand, I'm going to try to get some AG opinion, so I'm in a little firmer ground. I support the concept of this bill. What I don't want to do is run afoul of the Constitution or any federal laws unwittingly, so that's my position for now. But once I get the AG's opinion, I may change my mind on the Senate floor.
Chairman Smith.
Yes, on the bill. All right, what is, all right, Senate Bill 828 passes with the amendments 7-4. All right, that'll conclude the voting for tonight. We're going to wrap up, see if you can grab a little something to eat before the floor starts. I think, actually, is B&T still up? Is still B&T? They're done. So the floor is at 7. We are going to, floor starts tomorrow.
10.
Normal time 10. So we'll try to reconvene at some point in between our 2 sessions tomorrow.
I don't think there's two.
Or then we'll,
Yeah.
depends on how long the session goes then, we'll see. Okay. All right, see you all on the floor in a bit.